Welcome back to my channel! Wala pala akong channel.
Can we go closer now? Like let's do nothing but now. Where your heart out of my...
Good evening, sir. Good evening, classmates. My name is Arlante, the reporter for the Article 1188 to the Article 1193.
According to the Article 1188, the creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. For the first paragraph, it provides for actions to preserve creditor's right. So, dapat talaga. Otherwise, baka pagdating ng panahon, na-fulfill ng condition but he will not receive anything. Diba? So, kailangan nga i-preserve. Just take note that the action is for the preservation of his right. Now, this includes among others the right to go to court to prevent alienation or concealment of the property of the debtor, or the right to have it annotated in the registry of deeds. For example, on January 1, 2000, Ariana obliged herself to sell a parcel of land to Taylor if Taylor passes the CPA exams in October 2000. From the time the obligation was constituted and pending the happening of the condition, Taylor may cause the annotation of the condition in the certificate of title in the Register of Deeds where the land is located to preserve his right over the parcel of land, so that even if the parcel of land is alienated by Ariana, it will take that land subject to the right of Taylor. Now, on the second paragraph, it refers to the right of the debtor to recover what was paid by mistake. This is actually consistent with the principle of solutio in debiti. So for example, Mr. Obley obliged himself to pay Mr. Con 20,000 pesos if a PAL plane crashes at Cebu before December 30, 1998. After the obligation was constituted, and before December 30, 1998, a plane crashed in Cebu. Mr. Obley, honestly and believing that the condition was fulfilled, paid the 20,000 pesos to Mr. Con. It turned out, however, that it was the Cebu airline that crashed. Thus, Mr. Obley may recover the amount paid to Mr. Con by mistake for the reason that the condition has not yet been fulfilled. Article 1189 says, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. First, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. Second, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. Third, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Fourth, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with indemnity for damages in either case. Fifth, if the thing is improved by nature or by time, the improvement shall inure to the benefit of the creditor. Lastly, if it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. In this provision, it discusses about the loss, deterioration, and improvement during the pendency of the condition. But first, please keep in mind that this article applies only if: number 1, the suspensive condition is fulfilled. Number 2, the object is specific or determinate, not generic. So, ano nga ba itong tatlong sitwasyon na pwedeng mangyari sa object ng obligation kapag pending yung fulfillment nito? Number 1 is loss, or pwedeng mawala. Number 2 is magde-deteriorate, and number 3 is pwede ring mag-improve. And it may be loss without the fault of the debtor or with the fault of the debtor. Same way, pwede rin siyang mag-deteriorate without the fault of the debtor or with the fault of the debtor. And the last scenario, pwede rin siyang mag-improve by nature or time or through the expense of the debtor. Okay? So, before we discuss, mag-define muna tayo ng mga legal terms. The first one is physical loss or when a thing perishes, as when a house is burned and reduced to ashes. The next one is the legal loss. This is when a thing goes out of commerce or when a thing heretofore legal becomes illegal. So for example, during the Japanese occupation, American dollars had become impossible since their use was forbidden by the belligerent occupant. So the last one is the civil loss. When a thing disappears in such a way that its existence is unknown. So, hindi na natin alam kung saan siya napunta. Like, for example, yung aso na missing for some time na nawala at di mo na alam kung saan siya napunta. Or even if known, it cannot be recovered. So, example dito is yung singsing na nahulog mo sa dagat. So, alam mo yung place kung saan nahulog yung singsing which is doon sa dagat. Pero, mahirap na siyang ma-recover. Or of law where a property is lost through prescription. To better understand the legal implications of this article, let's have these illustrative examples. Chris promised to give Kim his only car if Kim passed the bar exam. Pending the result ng bar exam, nasira totally si car dahil nagkaroon ng earthquake, which is again a fortuitous event and is without the fault of Chris. So, when Kim passes the bar exam, does Chris have to give new thing? If your answer is no, then that's right. Kasi ang sabi nga diba, ang fortuitous event means wala siyang kasalanan, the thing is lost without her fault, so the obligation is extinguished. Pero her only car to a specific thing. So instead of her car, yung promise ni Chris is to give a 1 million pesos. So now, Kim passes the bar exam. Pero, pending pa yung result ng bar exam is nasunog yung pera. But without the fault of Chris. So, let's assume na dahil sa earthquake, nagkaroon ng sunog. And, kasama sa nasunog yung 1 million na pambibigay sana ni Chris kay Kim. So, nung pumasa na si Kim sa bar exam, ang tanong, does Chris still have to give Kim a 1 million pesos? The answer would be yes, because money is generic. Sabi nga diba that genius never perishes. So, balik ulit tayo dun sa scenario ng car of Kim and Chris. Now, suppose the loss occurred due to the fault of Chris. So, ano na? According to Article 1189, if the thing is lost due to the fault of the debtor, she shall pay damages. So, kung yung car is nawala dahil sa kapabayaan ni Chris, she shall pay the damages to Kim. And that's it. Punta na tayo sa next scenario which is the deterioration. So, if pending pa sa pagpasa ng bar exam si Kim, yung car naman ni Chris ay nag-deteriorate kasi nga naman, ang tagal pumasa ni Kim. So, without the fault of Chris, nag-deteriorate ngayon yung car. So, question, will Chris be liable for the depreciation? Or it would be Kim who will suffer the deterioration? Article 1189 says, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. So, meaning, it is Kim who will suffer the deterioration. Dito, since it's not the fault of Chris naman, the creditor or si Kim ang magsasuffer ng deterioration or the impairment. Now, what if na-deteriorate yung car dahil sa fault ni Chris? Let us say, hindi siya naging responsible or pinabayaan niya lang yung sasakyan doon sa labas. As a result, ang laki ng na-deteriorate ng car. So dito, si Kim ay pwedeng mamili between either is rescission, where the rescission is the cancellation ng agreement plus damages. Or second, pwede ring fulfillment of the obligation plus damages. So, despite the deterioration nga, ipapa-fulfill niya pa rin or ipapa-deliver niya pa rin yung car plus damages. So, yun yon. Gets? The last one, improvement. Paano kung hindi naman na-deteriorate? Let's say, nag-improve pa nga yung car. Who gets the improvement and who gets the benefit? So, depende ulit. If it is improved by nature and time, si creditor pa rin yung magbe-benefit. So, this is to compensate the creditor kasi kapag nag-deteriorate, si creditor yung magsasuffer. So, pag nag-improve, dapat sa kanya pa rin yung benefit. And sa example natin is si Kim yung creditor, so siya yung magbe-benefit. What if yung improvement ay galing sa expense of the debtor? Sabi nga ni Article 1189, she shall have no other right than the granted to the usufructuary. So, meaning, if Chris installed air conditioning unit inside the car and the day after Kim passed the bar exam, si Chris ay may right to remove the air conditioning unit if it will not cause destruction or injury to the car. Otherwise, kung ito ay magkakos ng damage doon sa car, Chris is obliged to deliver the car with the improvement because his right is only that of a usufructuary. When we say usufructuary, ito yung parang used as an enjoyment of the same lang, pero yung ownership is hindi naman sa'yo. According to the Article 1190, when the conditions have for their purpose the extinguishment of an obligation to give, the parties upon the fulfillment of said conditions shall return to each other what they have received. In case of loss, deterioration, or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for obligations to do or not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. So, dito naman yung effect of fulfillment of the resolutory condition. Alam naman natin from the start that the obligation is extinguished. Demandable at once. Pag nangyari ang condition, mawawala o ma-extinguished yung obligation. Second, dahil ang obligation ay na-extinguish na, the parties should return or restore to each other what they have received including the fruits and interest. So, dapat ibalik nila sa isa't isa yung natanggap nila. Kabilang na doon dapat is yung fruits and interest. Sinabi rin dito yung Rule 1189, it will apply to whoever has got a duty to return in case of loss, deterioration, or improvement of the thing. So, ganun pa rin yung rule. So, let's have this example. Si Chris, binilahan niya si Kim ng land with a condition na hindi magjojowa si Kim. After a month, nagkaroon ng jowa si Kim. So, ano na ngayon ang mangyayari sa obligation? Di yung obligation ni Chris has been extinguished. Like as if there was no obligation at all. Therefore, si Kim has to return the land and the fruits she received. Suppose in the meantime, the land has improved by nature and time. So, who benefits from the improvement? Sino na ngayon yung makikinabang? The answer is si Chris, because she is now the creditor who will benefit the recovery of the land. Kasi si Kim na yung may obligation to return. So, parang si Kim na yung debtor or obligor, tapos si Chris na yung creditor or obligee. So, again, the effect of the happening of the condition is to annul the obligation as if it had never been constituted at all. And, if the obligation is to do or not to do, the courts are given the power to determine the retroactivity of the fulfillment of the condition. According to the Article 1191, the power to rescind obligations is implied in reciprocal ones. in case of one obligor should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation with payment of damages in either case. He may also seek rescission even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claim unless there be just cause authorizing the fixing of the period. This is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with the Articles 1385 and 1388 and the Mortgage Law. So, this provision talks about the right to rescind. The right to rescind, as this article mean, the right to cancel the contract or yung karapatan upang kanselahin ng kontrata in case of non-fulfillment in the part of one party. The characteristics of this right to rescind under the Article 1191, sabi, it exists only in reciprocal obligations. So, question, what is reciprocal obligations? Reciprocal obligations are obligations where two parties are reciprocally obliged to do or to give something. Yung example nito is yung contract of sale where both parties are reciprocally obliged. It is not enough that both parties are indebted to each other. The cost must be identical, and the obligation should arise simultaneously. The buyer can rescind if the seller does not deliver, and the seller can rescind if the buyer does not pay. Pero kung ganito, si Alex nanghiram kay Tony ng 1 million. And at the same time, si Alex ay mayroong paupahan kung saan umuupa rin si Tony. So dahil dito, may dapat ring bayarin si Tony kay Alex na 1 million. So question, is this a reciprocal obligation? If your answer is no, then you're right. Although they are mutually bound, the cost does not arise from the same contract. Diba? So magkaiba yun. It's not what is meant by the reciprocal obligations. Now, another characteristics of a right to rescind, it can be demanded only if the party is ready, willing, and able to comply with his own obligations and the other is not. Otherwise, if wala naman sa kanila yung ready and able to do their obligations, edi wala rin sa kanila yung pwedeng mag-rescind. Dapat kung magre-rescind ka, may kakayahan kang i-deliver or i-fulfill yung obligations mo. Okay? So, dapat ready ka or able ka. Third, the right to rescind is implied. So, there is no need to stipulate the contract. The right is not automatic or absolute. So, the injured party should apply to the court for the decree of rescission. So, exception to the rule when judicial approval is necessary for rescission. So, ano nga ba yung exception na kung saan yung judicial approval ay hindi na kailangan para mag-rescind? Number 1, when the object is not yet delivered. Halimbawa is yung kontrata ng pagbebenta ng car. So, binenta mo yung sasakyan mo. Pero, hindi mo pa rin na i-deliver. At hindi pa rin nagbabayad yung supposedly bibili ng sasakyan mo sa napag-usapang date. In this case, hindi na kailangan ng judicial approval to rescind the contract. Automatic na yon. And for number 2, even if there has been delivery, the contract states that either party can rescind the same kung nasa stipulation ng contract nyo mismo. Yung remedies of the injured or the agreed party are alternative and not cumulative. That is, siya ay pipili lamang sa isa sa mga remedies, hindi pwedeng dalawa. So, kapag yung isa ay hindi nakapag-comply ng obligation niya, yung may kakayahang mag-comply ay mamimili lamang either rescission plus damages or fulfillment of the obligations plus the damages. Ang only exception lang dito is yung nasa paragraph number 2. Ang sabi, pwede pa rin siyang humingi ng rescission kahit na he already choose fulfillment if yung fulfillment should become impossible. But take note, pag pinili ay ang rescission, pagkatapos ng pagpili ng rescission ng obligation, parang pinarescind mo na. He cannot thereafter demand its compliance. Kahit pa partial fulfillment, wala na. Kasi yung pinili mo, na-rescind mo na yung contract. The court is given discretionary power to fix a period instead of rescinding the obligation, especially if the breach is slight or casual. According to the Article 1192, in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. Both parties are guilty of breach. So, this provision contemplates two situations. First, the first infractor is known. So, alam kung sino yung naunang lumabag ng obligation. In this case, the liability of the first infractor should be equitably reduced. So, ayun nga, i-reduce yun kasi nilabag din naman nung second. So, now, kapag hindi natukoy kung alin sa kanilang dalawa ang unang infractor, the rule is that the contract shall be deemed extinguished and each shall bear his own damages. So, for example, Coco sold his television set to Melon. The agreement is that the set shall be delivered on October 1 at the house of Melon, and the payment shall be made by Melon upon delivery. But Coco did not deliver the set on October 1 in spite of a demand made by Melon. So 5 days later, Coco delivered the set, but Melon incurred in delay in paying the purchase price. In a suit between Coco and Melon, the liability of Coco for damages should be equitably tempered by the court, taking into consideration the breach also of the obligation on the part of Melon. If both allege that the other was the first infractor, and the court cannot determine who of the two is telling the truth, the contract shall be deemed extinguished and each shall bear his own damages. So this means that the contract shall not be enforced.